to discuss the legal and constitutional implications of the former Deputy Chief Justice's report. We are joined now by the Director of the Dullah Omar Institute, Professor Jaap de Visser, to take this conversation forward. Prof, thank you for your time. Teasing out the possibilities yesterday, the former Deputy Chief Justice, Dikgang Moseneke, said happily he doesn't have to answer the question of whether or not this will be allowable in terms of the Constitution as it stands. He will leave that to a court of competent jurisdiction, which the IEC can and is more than likely to approach. How much of a curveball has he thrown the IEC, but also the Constitutional Court, which is likely to be the court of competent jurisdiction?
Yes, hi Thulasizwe, thanks for having me. Yes, you can almost read the relief coming through the text when the former Deputy Chief Justice expressed himself on that matter and saying, it's not my call to make. He essentially presented two options. He said, one option would be to amend the Constitution, but it would require a 75% majority in the National Assembly and 6 out of the 9 provinces in the NCOP agreeing. And the former Deputy Chief Justice indicated that that would not be the preferred option, and that a better option would be for a competent court to address this issue. Now, we have a specialized electoral court that could possibly look into this issue, but the electoral court has the same status as a high court, and I would imagine that a government or the IEC would request direct access to the Constitutional Court and request the Constitutional Court to look into this issue. It's quite an exceptional scenario because normally what the Constitutional Court does is assessing whether law or conduct is consistent with the Constitution. And in this case, the Constitutional Court will be asked to actually override the Constitution because the Constitution actually forces an election to be held before the end of October or before the 3rd of November, to be precise. And what the court will now have to decide if government or the IEC indeed goes ahead and applies for an extension is whether or not that can be overridden given the special circumstances of what we find ourselves in.
And Prof, I mean, listening to you, you said as calmly as you can this whole idea of the Constitutional Court needing to not just interpret and test out law or conduct against the standard of the Constitution, but perhaps in this case extraordinarily needing to use your word, override the Constitution. Your calmness, belies the complexity of what they are dealing with here. This has never been done.
No, it hasn't. And I think, the former Deputy Chief Justice Dikgang Moseneke also expresses himself in the report on the extraordinary circumstances that we find ourselves in. And I think, listening to what Musi Maimane said, and I think it also appears in the report, as almost a emphatic statement to say this must be a once-off issue. We're not talking about a slippery slope. We're talking about a very special scenario. And I think that's also the reason why a constitutional amendment is not preferred, because you cannot do a constitutional amendment for one case only. You have to then write in some sort of exceptional a room for doing this again. And that is not what is on the cards. It should be a once-off postponement. Given the fact, and this is the argument of the inquiry, to say that if we hold elections by the end of October, they will not be free and fair, and they will then be, in the words of Moseneke, there will be a nullity, an election that does not produce a credible result, that are not free and fair, and therefore that, I think, would then be the argument for postponement.
I don't know, what's your sense, Prof, of the likelihood that a court such as the Constitutional Court would take up this invitation to do this once off? This is what specifically the Constitution says, but under the circumstances we are going to, I don't know, rule that in this one instance we can sort of amend, bend, or interpret in a particular way into the text of the Constitution that actually a postponement longer than 90 days after the end of the term of office of local government is allowable under these circumstances. I don't know, what's your sense about how likely the Apex Court is to respond positively to that invitation to do that?
Well, of course, the former Deputy Chief Justice was one of those Constitutional Court judges. And he, I think, perhaps quite surprisingly, comes out with this report and says, a court must make that call. So clearly, he would see prospect in that. Otherwise, he wouldn't make that suggestion. And also strongly steer away from a constitutional amendment in favor of approaching a court. And, he raises very important issues and basically says, people will die if we go ahead with the election. So that's a very strong argument. And we will not be able to do the things that we normally do around elections that would make those elections free and fair. One very practical example is independent candidates can be nominated for elections. And that's, one of the, I suppose, beautiful elements of our local government electoral system, which is now sort of the envy of national and provincial elections where independents are not yet possible. But for an independent to be nominated, you need to collect 50 signatures from voters in your ward. Now, how do you do that in a lockdown scenario? And how do you do that without endangering infections, etc.? So there are some very real impediments to free and fair elections. Leaving aside the issue of rallies and door-to-door campaigns and the impact this would have on smaller parties, and I think all those arguments will have to be canvassed in front of the Constitutional Court and probably will be opposed by some parties. And then the Constitutional Court will have to make a decision. But the fact that a former Deputy Chief Justice makes that recommendation, I think, would tell us a lot.
Yeah, absolutely. It will be interesting to see how it plays out. What about this argument that says postponing these elections would allow local government officials and political parties that are running the councils at the moment to escape accountability? Accountability is a big principle and a value in our constitution. Do we risk that by postponing by this, large amount of time, if it does happen, we sort of give them a get out of jail free kind of card, in that they won't be held accountable as scheduled, as regularly as they should by the voters?
It's by no means ideal. It certainly is not an ideal scenario. And you could say, justice delayed is justice denied. And you can make all those arguments. But in the end, it may also be overstating it a little bit, because we're talking about a few months. We're not talking about completely abandoning elections or giving them, another term, which also, was suggestion. The report is quite clear. We're just asking for a few months respite so that we can have the elections during a time when a lot more people would have been vaccinated. So I don't think it's a full escape of accountability. But of course, it's not ideal. And the report also says so. It talks about the protest. It talks about the Auditor General's results. And it says we need an election. It's time for a reset, in the words of the report. But we cannot risk the lives of South Africans in doing so.
All right, it will be fascinating to watch. Thank you for your insights here on ENCA. That's Professor Jaap de Visser from the Dullah Omar Institute joining us there and weighing in on the report of the former Deputy Chief Justice, Dikgang Moseneke, who basically has said that it's unlikely that the elections will be free and fair if they are held under the current conditions around October this year, and saying that they are likely to be free and fair if they are held by no later than end of February 2022. So